Following the Norman invasion of England in 1066, a system of centralised administration of justice was established, whereby judges went on circuit throughout the realm dispensing justice in accordance with the wishes of the king. This system attempted to avoid local lawmaking and in turn was aimed at strengthening the power of the king. In this way, the common law developed. However, the term common law has more than one meaning. It's also used to distinguish judge-made law from statute law. The former originates in the courts, while the latter is a product of the legislature's lawmaking power. Litigants suffer a range of disadvantages when attempting to bring a suit or action at common law. They had to bring their actions within one of the pre-existing suits. If one did not exist, the litigant would be without a remedy. Many powerful defendants could use their resources to pervert the course of justice, and in some areas, the common law was simply not effective. Judges' decisions were ignored. In addition, the range of available remedies at common law was limited. By far the most popular remedy was damages. However, this was ineffective in many situations, for example where the plaintiff sought to have the defendant restrained from doing an unlawful act. Therefore, it is not surprising that there was great dissatisfaction with the common law courts. As a result, the Lord Chancellor, the holder of the King's conscience, began to accept petitions from individual litigants from circa 1150. After a time, the procedure for hearing petitions developed and was formalised to some degree, leading to the creation of courts of equity or chancery. In this way, litigants could avoid the confines of the writ system. Finally, the courts of equity introduced a whole new range of remedies for plaintiffs, such as specific performance, rescission, and the injunction. And most importantly of all, they recognised the use or trust. However, by the middle of the 18th century, the common law judges were fiercely resisting the encroachment of equitable jurisdiction. It was becoming increasingly difficult to administer two systems of justice within the same legal regime. The main reason for this incompatibility was that while the early chancellors in theory acted on a number of settled principles in granting or refusing relief, there was little uniformity in the judgments handed down, and the types of remedies varied from one chancellor to the next. This lack of consistency and principle in lawmaking opened the courts of equity to the charge that equity varied like the chancellor's foot. However, the chancery courts moved swiftly to change their ways. It was not merely the lack of uniformity in adjudication which proved to be problematic. Many jurists believed the existence of two distinct legal systems to be anachronistic and unworkable. The fusion of law and equity. Academic and judicial debate continues to rage around the question of whether the fusion effected by the Judicature Act was merely procedural or also substantive in nature. As far back as 1880, Lord Jessel in Walsh and Lonsdale stated, "It was not any fusion or anything of the kind. It was the vesting in one tribunal the administration of law and equity in every cause, action or dispute which could come before that tribunal." In this context, substantive fusion suggests that, following the enactment of the Judicature Act, legal rights have been modified by equitable principles and equitable interests have been affected by the law. On the other hand, the proponents of procedural fusion argue that legal rights remain legal rights and equitable rights remain equitable rights, though administered in the same court.